I'll call our meeting to order. Please rise as you are able. We will have a moment of quiet personal reflection followed by the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Welcome to the regular scheduled public meeting of the Zoning Board of Appeals of the Shreveport-Caddo Parish Metropolitan Planning Commission. For public hearing agenda items, if you wish to make public comments on an application, we have comment slips at the speaker's stand next to the podium. For future notification purposes, it is very important that you fill out a slip and drop it in the box when you come forward to speak. Please state your full name, mailing address, and zip code before addressing the board. We will call each case on the agenda in order and hear first from the applicant, then those speaking in favor. 10 minutes are allotted for the principal spokesperson and 3 minutes for each additional speaker. We will then hear from those wishing to speak against an application. Again, 10 minutes are allotted for the principal spokesperson and 3 minutes for each additional speaker. One representative of the application may then speak in rebuttal if desired. After hearing comments on each case, the board will then immediately deliberate and vote on that case before moving on to the next case on our agenda. Please note that when the board is deliberating, members of the public are not permitted to comment. Any member of the public may request a copy of the board's decisions on a particular case by contacting our office at 318-673-6480 after 1 p.m. tomorrow, or by accessing our website at Shreveport-Caddo-MPC.com. All ZBA decisions on variances to zoning within the city limits of Shreveport are subject to appeal to district court. All decisions on special exception uses within the city limits of Shreveport are subject to appeal to City Council. Please note that it is your responsibility to contact either district court or the City Council about their procedures as related to the matter you are concerned with. Copies of this document and the phone numbers to contact the governing bodies are available on the table next to the podium and in the entryway to this room. As a courtesy, please remember to turn off all cell phones while the ZBA is in session. The Zoning Board of Appeals values your testimony today and appreciates your compliance with these guidelines. All right, our last meeting was February 15th. What do we hear regarding the minutes from that meeting?
Move to approve the minutes.
Second.
Motion by Mr. Hendricks, second by Mr. Crawford to approve. Please open for voting, and please vote. Motion carries unanimously. All right, today our first case is case number 22-39, BAC, a variance at 737 Linden Street.
Mr. Chairman,
Yes, sir.
I'll be recusing myself from this case. I wanted to make it public due to the applicant's prior relationship with my current employer, Willis Knight.
All right, thank you, Mr. Crawford. All right, Mr. Hussain.
Thank you, Board, for giving me the chance to present my case. Thank you, Mr. Crawford. I'm Sunny Hussain.
Okay. Make sure you get your address in.
Yes, sir.
Okay, thank you.
I live in 737 Linden Street. I co-own property with my wife, and today's variance is about a setback of a shade. I have a neurological condition, and I need a special device to stretch myself, which is 6 feet long and 4 feet wide, and it needs to be electrically wired to be charged. I'm a fall risk as well, and it is not advised to keep it inside the house. Can I tip over? And I have attached a photograph of my disability, which shows I'm a frequent fall risk. So I work with Tuff Shed, which is a nationally reputable company. They are based in Dallas, Fort Worth. Tuff Shed is Tuff Shed, SHED. And I had a contract with them to install minimum size shade which can contain that device, medical device. And they installed that, and they got a 10 by 14 shade outside the house, and their understanding was that there's no zoning requirement because they work mainly in Texas. They also have a branch in Louisiana. So after they put it in, we got a citation. Basically, we got a violation. And after that, Duff said legal got involved, and their employees worked with the city of Shreveport. They wanted to get it right. So there's an exhibit number 1 for all of you, sir, which shows that Norman Favor from Tough Shade is working with Robert Pease, his inspector, zoning inspector from city of Shreveport. They were in direct communication with the legal of Tough Shade to get the permit and get the dimension correct, the site correct, and it was a lot of work for them. Tough Shade wasn't happy because they built their shade from, it's custom built. They have to build it on site. They bring the material in a truck and build it. So they had to tear it down. And so this time they wanted to get it right with all the dimensions. So exhibit 2 shows application which was verified by zoning inspector, MPC inspector Antonio Lyles. So Robert Pease and he were both involved with, so 2 inspectors were involved, and it's in the application as well. It was approved, and exhibit 3 is the permit we got from the city in conjunction with Tough Shade Legal, corporate legal, and after that they pursued the work. And the dimension of the shade, 7 by 10 now, downgraded to the minimum size from 10 by 14, which can contain the instrument. It has been anchored, and it also has conduit, electrical conduit to it, which was permit obtained for that. Exhibit 4 is a copy of the settlement with Tough Shade. It went to the court, so they wanted a proper settlement. A copy says that a permit has been obtained by the city and the other terms. It's a final settlement, and they will not provide any more service after that. So after putting that, all the matters were resolved, but MPC got a complaint from my next door neighbor, Ms. Kathleen Bluefield. She cited violation, and I got a letter of violation again. So I didn't understand it when we worked so hard, and so Mr. Alan Clark, the director, got involved, and at some point he tried to explain to me, and then he paid a visit to my house, and he explained that it is there's a 5-foot regulation. Although the permit was given properly, it is illegal. Mr. Clark has some authority of some kind as a director to still call a violation of a legal permit. So after that, I was a little lost because the matter was also, I got a criminal citation. Mr. Clark referred me and my wife a criminal citation, and I got served, and that is due on May 16th. So for me, I little got confused, and so I reached out to MPC attorney who represents MPC Caddo, Mr. Reginald Irving, and he advised that Mr. Clark may have authority to call a violation, although this is a legal permit, and my best bet is to appeal with the zoning board and see what decision they can overcome, because you have a legal permit. Mr. Clark's letter is Exhibit 5, if you want to look at it. Also, in terms of the medical MPC staff remarks, it is probably all of you got a copy of it. It said that I have followed every rules. It's legally obtained permit. The structure was permitted due to understanding that the shades was allowed to be built is all there in the remarks section. And they also did subsequent assessment of the property. There's like a 40% of the total yard, which has to be less than. There's some criteria which also has been approved. So still I got a violation notice, and I want to appeal to the zoning board that you uphold the permit, and basically so I come out of this violation and get along with my need of this shade. I have looked into the response from the neighbors, which is also allowed by the MPC. I just wanted to bring a point that I am the only a minority. I'm the only colored person in the whole stretch of Linden Street, from Fairfield to Highland. It's about 100 houses. I'm the only colored person. I just do my work. I don't interact much with it. I give to myself. So I haven't done any campaign or try to get any letters from anybody, but it looks like that the oppositions are mainly about some flooding issues in the property. I wanted to also bring it to that I have been singled out for a flooding problem in the whole area, but historically, Linden Street is a slope from Line Avenue all the way to Highland. So it is a high area, Line Avenue. That's how historically has been. Maybe it was put dirt work at that point. After that, it goes very sharp slope either side. So every neighbor down the slope has a flood water problem. When I bought this house in 2008, I soon realized I have a lot of water logging in the back. When it rains, it's so bad that I feel like I'm drowning. So I put one sump up. After that, I got 2 other drainage folks to work on it. I have all the drainage going all the way up to the Linden Street. And then I realized we have a problem. Still, when it rains a lot, as if like the house is gonna be flooded. So everyone has a problem. And it took me a while to understand the magnitude of it. So at some point, even myself, I thought that all the water is coming from my next door neighbor, Susan Rice. So this is exhibit 6, which shows the communication with the insurance companies and the lawyers. When I was concerned that my neighbor is causing it, but they explained that it is not anybody's fault. It's the topography of the land. When it rains, the water drains all. You can see the water going all the way. So if you put all the drains in the, say, if someone wants to resolve the problem, mitigate it, the drains you cannot put in the city drain. That's illegal. So you got to put it all the way up to the Linden Street, and you can clearly see that it all go down the slope. So the water logging issue will need a collective approach, not finger pointing, and the city of Shreveport needs to get involved. And because we need some direction, collective direction. Otherwise, we'll be finger pointing in like a Hunger game, blaming each other and get mad. My neighbor, Miss Catherine Bloomfield, also in 2014 cited a complaint with Patrick Furlong, the city engineer. It's all included in her complaint. It's part of your package, MPC package. She demanded that city is responsible for her flooding problem in the back and wanted $30,000 compensation. So Patrick Furlong office, they explained to her, and they also called me that, hey, it's nobody's fault. It's not city's fault. It's not your neighbor's fault. It's the slope. So subsequently, everybody working on the drainage issues and stuff. I understand the concerns of the neighbor, and if you look into the exhibit 8, I got a plan. After I see, nobody has spoken to me directly about these issues, so now I saw the MPC remarks. They were attached to it. There's a quote for it to give a holistic solution for it. At the end, the flooding has nothing to do with 2-foot variance. If you leave the shade there, if you move it, even if you break it, whatever it is, the flooding has to be, it's a separate issue. But I can see the concern that, because disinformation can spread that, oh, this is his fault. Like I thought my neighbor was responsible. Now everyone thought that I'm responsible.
Thank you, Mr. Hussain. I have to call you for time.
Yes.
I will say, in following up to what you just said, I will remind the board and everyone here today that what is before us is a variance on the position of the shed relative to the property line. We have no jurisdiction over drainage or irrigation, so those are not anything that we can take action on today. The only thing we are here to affirm or reject is the distance between the shed and the fence. With that, are there any questions for Mr. Hussain?
I have a question.
Mr. Hendricks?
Mr. Hussain, you put Exhibit 5 in your packet, and I'm looking down about 4 or 5 sentences, and it says, and this letter is from Mr. Alan Clark to you. It says, I requested that you advise the city of Shreveport as to the cost to move the shed the necessary 2 feet to bring the structure into compliance. Are you aware that the city, they understand that it made a mistake, but they're ask you to come up with an amount or cost that it will take to rectify the situation. Did you do that?
Mr. Clark, when he visited that, before he wrote the letter, he didn't know about the ramp I need. If you look into the picture of the ramp, of the shade, it has a, because my problem is I cannot bend my leg. I had a brain surgery, I was paralyzed on the left side. So the problem is that I need to grab something, and the problem is without that ramp, I cannot walk in. So that's slow. He wasn't aware of that. Now, including the ramp, so when they asked me for, he also said that either you can have it as move or you can get a variance. When I went to pay for the variance application, there are two city officers there, Annie Peck and Glenda Wells. They said, what is this variance for? Then I said that this is, Mr. Clark asked me to submit this for that shade. She said, your shade is correct and you don't need a variance. Mr. Clark knows it. He's doing it as to help, doing a favor to somebody, like a political favor. It is, you are right, and you can go there, but you will be overruled. They know each other. So I got a little lost. I lost my faith on MPC, and they set me like a date, and I thought, what I'm going to go there, and nothing's going to work. They won't listen to me, so I didn't show up. So they gave me a criminal violation. But I talked to Reginald Irving and Ron Letty at that time, the city attorney, see whether I can resolve this issue. So after that, there's a rank and file in MPC, Glenda Wells, Annie Peck, and also the city, all the MPC inspectors. They feel that I've been giving undue hardship because Director Clark is trying to do political favor to some people. You know, my neighbor Catherine Bloomfield is well connected. She's an attorney, and I have done everything to get this shade. This is unnecessary harassment. But I won't say that. Mr. Reginald Irwin was very nice. He said, hey, why don't you give it a go with me? He again said that, okay, get that site plan for me, get a good dimension for the ramp and everything. Let me understand this, and I'm going to get you a meeting. He helped me get this meeting. Mr. Clark he wants me to throw out with a criminal violation. That's wrong. Fundamentally, that's abuse of power.
Okay, now my question is this. Did you at any point in time get back with the city to rectify the problem with either moving the shed or anything
So tough
else?
shade, if you look into the settlement, they won't do anything. This is a custom build. For them, they have already eaten up a cost of the first shade. They have to eat up the second. They cannot break it. They cannot move it. Their shades are custom built, and the warranty exhibits that you cannot move it. They're anchored, and there's got electric wire and everything attached to it. I can give the legal number. If city wants to use their money for a valid permit to overrule it, I'm happy to give it to them. I offered that, but I lost my faith on Director Clark. I thought he was taking sides.
Okay, my question one more time. The city asked you to get with them about the cost to move the shed or do something. Did you do that?
So tough shade the legal settlement is done. I won't have any way of getting that cost. It has to be tough shade. It's a brand shade. I can give the number to you, and city can contact tough shade to get the amount, but I won't have the cost estimate. No, I don't.
Okay.
It's a delicate matter. Yeah. It's a legal matter. You can see the settlement.
Mr. Woods?
I don't think you understand his question. He sounds like Mr. Clark was willing to pay to have it moved, and I think his question, or my question is, are you aware that the city was willing to pay because they had given you the permit? Are you aware that they was willing to pay, the city to pay, to have it moved for you?
Correct. So the first thing is the structural, it cannot be moved. Second thing, if city wants to move, there's no room for it. So if you look into the map, which Mr. Reginald Jordan asked me to draw, so I got a drone to draw the whole, my whole property line. There's no space to move it, and you can't even move 6 inches. It is very tight over there. That's why the inspectors gave me a 3-foot variance exception, and that is part of the Unified Development Code of Shreveport. That's part of the permitted encroachment 3 feet. If you look into that, Your Honor, that's the yellow is the shade, and if you see the fence line, it is 3 feet from there, which is according to the permit. And if you look into the ramp, it's literally touching the building. There's no place to move it. And that's why Mr. Reginald Jordan got me to this MPC meeting. And Mr. Clark knew about this before he gave me the criminal violation.
if you move, if you move the shed towards the sidewalk, and I see a sidewalk there, is that
There's a
your-
sidewalk barely touches, it touches the house, structure of the house. It's barely you can walk.
I'm not seeing that, sir.
So shade, and that's the main structure of the house. And the sidewalk is about, the dimension is there exactly. Let me check. It's all measured.
That's the angle of that picture, this is a different picture.
I will tell you, sir. Let me look at it.
How much would he have to move it that way? He said that's 3 feet.
The sidewalk is 3 feet 2 inches. If you move it, I won't have any walk. The air conditioners are behind it. They won't access. We are blocking the access.
I have another question for you.
Yes, sir.
If you do move this structure 2 feet to make it into compliance, the ramp that you're talking about, can you turn the ramp sideways where you can come up and then turn into the building?
It goes all the way back to the air conditioned utilities. So behind the shade, there are air conditions, and it's a 2-story house. There are 3 air conditions, and there's a generator on the back. That's the only access there.
So my question is,
Yes, sir.
the way that your ramp is positioned, you're going straight up into the structure there. Can't you turn the ramp sideways and come up and turn and go into your property?
I believe it is possible. This is also a tough shade ramp. It comes with it. It was approved like that. Problem is, anything I touch it, there won't be any warranty on it. And there's also electric, you can see the electric insertion conduit and everything. It is so tightly done. That's why the legal got involved. They said, we are not doing it again. We got $50,000 loss on one shade. They had all the labor and everything involved. But if Tough Shed can do it, city can work with them, I have no problem. But where to move it? There's no space to move it.
Okay. I don't have any questions.
Any more questions for Mr. Hussain? Thank you, sir.
Yes.
Anyone else wishing to speak for case 22-39 BAC? Anyone here to speak against case 22-39 BAC? I'll remind you the initial speaker has 10 minutes.
Thank you, Member Berry. My name is Mark Odom. I'm an attorney, member of the Louisiana State Bar, Shreveport Bar Association. I've been retained by Miss Catherine Bloomfield, the immediate neighbor that Mr. Hussain spoke of, to his,
Sorry, I'm sorry, I need your mailing address.
yes, 910 Piermont Road, Suite 410, Shreveport, 71106.
Thank you.
Ms. Bloomfield is herself an attorney, but her docket was such that she couldn't appear today, and she's retained me to speak for her. But I'm not just retained on this matter here today. This is a matter that's grown cumulatively over time to where now it's a big mess. We've all heard the old adage, the straw that broke the animal's back. Well, this isn't the last straw. This so relatively small building, the animal's back's already broken. Mr. Hussain has added numerous structures to his property over a period of time, and they cumulatively have added so much. The original application only listed what was the main residence, which is at the bottom of that satellite view. If the board will note that the add-on is as much square footage, if not more, than the original home was. And then there's been an add-on to the add-on where a closet was added. And then if you'll note in the far back or to the south, on the top part of that diagram, there's what's labeled pergolas. Well, they're not just pergolas. They're
I'm going to interrupt you for a second and just ask, how is this relevant to the shed? Because the only thing in front of us today is the
Yes.
shed and its relative position to the fence
And
or the property
this-
line.
Thank you, Mr. Berry, Member Berry. This is a foundation to the point that the permit shouldn't have been granted for any reason. Several of these other things all have paved bases, well more than the permitted amount of square footage of the backyard over the overall lot is now impervious. It's been paved over, built over, and part of our concern is some of the permits, some of the work that was done without permit. Some of it was done with unlicensed contractors. Some of it, even when the permits were issued, shouldn't have been permitted. Ms. Bloomfield did a public records request. None of the previous permits issued to the applicant asked for or required a stormwater retention plan, which should have been required or mandated.
Okay, but again, none of that is our responsibility and not in front of us today.
Well, here's where I'm going with that. I apologize for the lengthy introduction. The animal's back is already broken, meaning most of his water is going on to Miss Bloomfield's property. Yes, it does drain naturally from west to east, but everybody has, under the regulations, under the ordinances, a certain amount of pervious and impervious ground that's allowed, which is what offsets most of that. But the applicant has very little left. All of his water is going on to my client's property. And if we'll have that second photograph that well, that's one. The next one.
Okay, I hate to be a broken record, but that has nothing to do with the shed, sir.
So where I'm going is a variance shouldn't be granted under any circumstances because he's already causing damage. He's already, all his property, including, this will just exacerbate it more, as Ms. Bloomfield put it in her written comments. Any more square footage of any kind. One of the reasons that, as Member Hendrick's questions were and Wood's questions were well taken, well, how can you squeeze this thing in there? The whole problem is you can't, because he's developed his whole backyard so much there's no place else to put it. He doesn't have enough room. He's over the limit on the amount of pervious and impervious ratio of coverage of his yard. And for that reason, I believe the recommendations of the staff on here was against it, and I think they used the term are self-imposed, because he's built so much back there. He didn't have any place else to put his shed. He's paid well more than the permitted amount of the area, and therefore, even if he moved his shed a few feet to the right to be outside the 5 feet, which I understand is the limit of the jurisdiction and issue before this board. But the very fact that it's there anywhere, within the setback or not, is exacerbating a problem that's gone on for years, and it's gotten worse. The photograph I just put back up, if you put that back up of the underneath of the home, Miss Bloomfield's home already has stuff like this, water standing under her home. And as I said at the beginning, we're contemplating other civil action for damages, perhaps injunctive relief, to not only to actually remove some items because they are causing the damage. Obviously, that's yet to be developed and that sort of thing. But at the very least, and how it does relate, remember, Barry, to this limited variance request, is that to allow a variance, even elsewhere on the property, just exacerbates the problem. He's got a terrible problem. And procedurally, I think, we note that the citation was issued back on the 29th of July of last year. The applicant didn't appeal it within the time frame to do that. And so this is kind of what appears to us to be an end run around the fact that he didn't appeal it. He didn't appeal it timely, which is what he should have done if he wanted to question whether the permit denial or the citation was valid. And I've seen no evidence of any disability or special circumstances to allow him to continue and exacerbate a problem that's been building for years, damaging my client's property. And I think you see in your record there's some others that'll speak, and if they're here, they'll speak verbally on that. It's affecting drainage on Wilder, the street to the south, and other lots besides my client, Miss Bloomfield, to the south. But she's bearing the brunt of this. The reason these ordinances are put in place and supposed to be enforced in the permitting process is to protect from this very kind of thing. And so, yes, it's not within the jurisdiction and the issue before this board today to order it removed, but certainly don't grant more leeway to do more damage of a problem that's way beyond the limits already. This isn't the last straw to break the animal's back. The animal's back is broken, And we asked that this board not make it worse by allowing Mr. HUSSAIN a variance that really has no basis for it, and it's only going to make things worse, whether he moves it or not. I'll take any other questions if the board members have some.
All right, any questions from the board? Thank you, sir. Anyone else wish to speak against case 22-39 BAC?
My name is Simeon Wall, and I am a neighbor of Dr. HUSSAIN there, and my backyard backs up to his, and so I came here to speak against the variance since we have a tremendous water problem on Wilder Place. I know you have nothing to do with that.
I need your mailing address, please.
726 Wilder Place, 71104.
Thank you, sir. Please continue.
And so I came here representing and speaking with Ginger Paul, who is at 720 Wilder Place, and also Sam Kamak, who's at 206 Wilder Place. And my address is 726. And we have had water problems for the last 25, 30 years because of the buildup at Dr. HUSSAIN's place. And I think all that water just runs off his property. As you see, with that much roof surface, that all the water has to drain somewhere. And our property, our backyards are about 18 inches on the average lower than his backyard. And so we feel like that 70% of that water comes to our yards, and we have had tremendous flooding problems. I have a sump pump in the backyard to drain my back lot, which is empty, has nothing in it, and it's usually a mud lake whenever we have a torrential rain. So rather than belabor the point, we're unhappy with all the water because we are about 18 inches less than all the water in Wilder Place. On Wilder Street will have to drain forward toward the street, because not only does our water drain forward to the street, but their water, being that he's facing the north side, his water has to drain down Linden. But our backyards are the ones that get all the excess rain that would land at 737 Linden. But I speak against the variance because we don't need any more excess water running into our backyards.
Thank you, Dr. Wall. Anyone else wish to speak against case 22-39 BAC? All right. Mr. HUSSAIN, you have an opportunity for rebuttal if you care. 3 minutes, please.
So thank you, Dr. Wall, for your comments. As Dr. Wall said that he and Ginger Paul and others on the Wilder Street having this problem for 20, 25 years, the water problem. I have been there only 13 years. So this pre-exists me. So very word of Dr. Wall, your problem actually pre-exists me. And I do acknowledge the pond issue. If you look at the pond Dr. Wall is talking about, that's actually a water retention pond. It's not a luxury pond. It is to create, just to retain the rainwater. I get so much, everybody, I get so much water. So that is a retention. Every now and then the auto valve of the pond, it basically, we need to bring it down. That's the plan, one of the plan which I proposed with the irrigation. Now I know, Dr. Wall never told me these issues are personally, you could have called me, but it has to be mitigated. And we all need to work together, collaboratively, and city needs to help us with this, that some direction. Otherwise, we're going to blame each other, get angry with each other.
Okay.
Regarding the variance.
Any other comments about your shed or the variance?
I honestly think that I have done my due diligence. I have done everything. I have changed it from one violation to other, and this is not gonna stop. I think because no matter what I do, and I think if you look into the very complaints of the neighbors, they're copy and paste. I purchased my property because of the age of this neighborhood, scale of this, and pets and outdoor ratings. It's a copy of paste from Miss Catherine Bloomfield's to one after another. It basically says that you don't belong here. We don't like you here. And as a neighbor, I cannot change myself. I am who I am. I'm a colored person in a white neighborhood, and I can be getting this again and again, but I have to stand up. And MPC has honest people. They do their job, they're proud of it. Reginald Irwin, Annie Beck, Glenda Wells, talk to them. How many times I have been, they send me through me. Every time Catherine Bloomfield calls the phone, she doesn't feel good, she calls MPC, Alan Clark sends the agent, harass him. This is stop. Every officer of MPC has a power. There should be check and balance. I want board to urge it, please approve my variance and stop the harassment. We all are accountable. This is public money. Every time we send something, I got a legal permit. I got everything with it. Why would you spend city money to kind of unfounded water problem to move my shade because somebody feel not like it? This is city money. It's my tax money, your tax money. Why would you waste it? Because Alan Clark can. He can send every time. You see, Reginald Irving has other things to do. Just send them because Catherine, his friend called. That's wrong, fundamentally wrong. Kindly approve the variance. So I think that, as you say, that my next step is, if it is denied, district court, right?
Yes, sir.
Thank you, sir.
All right, Mr. Hendricks, you had a question?
My question is directed toward Mr. Clark. In the letter that you emailed to Mr. Hussain, September 14th, 2022, is that offer still on the board for him to come to the city to fix the issue or offer assistance?
I did not make the offer, Mr. Hendricks. The offer was made with risk management and the city attorney's office. Excuse me. If you are interested in me finding out from them if that is still, it was rejected by Dr. Hussain. And once it was rejected, the city attorney's office moved on to something else. But if you want me to check into our attorney at the guards possibly could answer that question for you.
Okay.
Michael, we would have to revisit it, as Mr. Clark articulated, because that was a while back under a different administration. And so we would have to review the issue and come back to the board with whatever resolution we come about.
Okay. That will require another meeting, right?
Correct.
Okay.
I have a question, yes. Now then, the question is, if that is the case, is Mr. Hussain willing to deal with that? That's the question now. In other words, there's no point taking it up if he's not.
Right. I'm sorry, Mr. Hussain, I can't have you back to the
Oh,
microphone.
okay, I got it.
And I need a motion on the table if we're gonna get into discussion.
I move that we go out of order to discussion, for discussion.
Okay, we have a second?
I second.
Can we do that?
What was the
What
motion?
was the
I couldn't
motion?
hear.
We
What was
couldn't hear the
motion?
motion.
The motion is to go out of order to have a discussion before we get a motion for deliberation.
I will yield to the attorney.
You will have to have a motion directly on what's on the table, so whether you grant or deny the variance. And then you can discuss, and if you change the motion, then you can withdraw it and put
Right.
in the motion.
Yeah, so we need to get a motion one way or the other, which you always have the right to rescind.
Me?
I move that we deny the variance.
All right, a motion by Mr. Brandon to deny,
Second.
second by Mr. Hendricks. All right, so now we are free for discussion.
The discussion I had, I don't think, Mr. Hussain, that you're taking the opportunity that the city gave you. If someone's going to come to me and say, hey, we'll fix the problem, let them come and try to fix the problem. That's the problem I have with what's going on right now. You didn't give them the opportunity to come to your home to try to rectify the problem. That's what my discussion.
Okay.
And-
Mr. Woods?
And to add to that, if the city attorney is advising that they would have to check to see whether or not the offer is still on the table, it comes back again as to whether or not it would do us any good to put it back on the table if you're unwilling, if he's unwilling. So how do we get the answer to whether he will be amenable to what my board member here is suggesting?
Well, based on what I've heard today, he is not. He would not find,
Are you-
he would not
May I-
find a.
May I come?
You may not, sir, sorry.
Oh.
He was asked, and he said that if we wanted to deal with it, we'd have to deal with Tough Shed. He's not interested in going down that road, in my opinion, based on what he said today. So I think we're
No,
past
I'm
that.
willing,
I think
I'm willing to work with the city, but I think Tough Shed will not take ball from me. It has to be the
And
city
so-
attorney's office.
And so I think we have to go on the assumption that the city is not gonna pursue something on his behalf with Tough Shed when it's, even if they were in error, you know,
Why would Tough Shed be part of it? The city's gonna do
because
it. They're
I
saying
I don't know, and those are questions I think that are beyond the.
No, I can contact them, Tough Shed. I can try, but I think it would be better
Mr.
for.
Hussain, I'm sorry, you're out of order. I
Oh,
can't have you
sure.
speaking. You don't have the floor.
Sure.
So the motion on the table is to deny. If anyone feels that that we should go another way, this is the time to speak and make your case. Otherwise, we'll vote on this.
Are you speaking to my board members?
Yes.
Arrest.
Okay, so motion on the table is to deny. Please vote. Open for voting. A yes vote is to deny, just to be clear. We're missing one vote. We're missing one vote. Mr. Woods, you didn't register.
I did. I abstained.
You're not missing a vote. It's also,
He
Mr.
abstained.
Crawford is not.
Oh, I see, okay. Very good. I couldn't see that from here.
Does he need a reason for abstaining?
He does need to state, you have to state your reason. I didn't
Yeah,
realize.
what-
you were
you have
abstaining.
to have a
I thought it
reason.
was-
Mr. Woods is abstaining. I'm asking, does he need Mr. Crawford has outlined his reason for abstaining.
Right, you have to vote yes or no, or give a reason why you're gonna abstain.
No, I didn't hit the wrong button. I abstained because I wanted to have a motion that would, he said he would work with the city and he was willing to. I don't know if he understood. I really don't know if he understood.
Well, it's okay. If we deny the variance, he still has that option. Because once the shed gets moved, he will no longer have a need for a variance.
No, I would have to pay for it.
Please stop talking, sir.
Oh.
Okay? I cannot entertain
He can always.
outbursts from the floor.
He can do it now.
Even though this is denied, he can go back to the city himself and talk to them, see if they're gonna.
Is that accurate?
If the city attorney is willing to talk to him about it, it is.
We would have to revisit it if the consensus is that that offer is still on the table, then that conversation would ensue with Mr. Hussain. But, so at this moment, I can't tell you yea or nay whether.
Right, but
will-
It has nothing to do with us right
It
now.
has nothing to do with us. It's incumbent on him to follow up with that as an option.
So I have to vote yes or no.
Please, sir,
At-
if you have any questions, please step to the side and speak to someone else. We can't have you continue to outburst, or I will ask you to leave the chamber.
Oh, okay.
At this point, the motion is carried anyway. Is that, am I right?
But you have to give a reason why. you're
I
abstaining.
understand, but my question is, which way I vote doesn't matter.
That's correct. But you have to go on record.
I understand, I will, but
Yes.
I wanna know for
That's
sure that
correct.
it doesn't matter.
That's correct.
Okay. Then I'll vote. Can you change it?
Needs to voice vote. Yeah, we did voice vote.
I vote with the panel, with the body, yes.
All right, so according to the voice vote, Mr. Woods votes yes, which means the motion carries unanimously. All right, case number 23-3, BAC, 2701 Catherine Street. Caddo Parish School Board, Kevin Bryan, architect. Did we know that they would not be here, or Any idea?
We have not been advised that they would or would not be here.
All right, well, the chair makes a motion to go out of order, put this case at the end in case Mr. Bryant's running late.
Second.
All right, we'll have to vote on this. Shari? Motion, did it go? Who are we missing?
I voted yes.
All right, yeah, motion carries unanimously. All right, case number 23-4 BAC. So I'll remind the applicants that you have one person may speak, not two at a time, and you have 10 minutes for the first. If someone else wishes to speak, it's 3 minutes. And I'll need your name and address.
Good afternoon. My name is Umekia Jenkins, and I live at 1415 Audrey Lane. That's in the MLK area. I'm here today trying to see if we can get approval to place a manufactured home at 5908 King Street in Shreveport. This is something that me and my husband have been discussing for a very long time, and we was fortunate enough to obtain 2 lots where we had we've already had it surveyed and everything pretty much completed, did all the paperwork and turned it in and paid fees and everything. So we finally got approved to get a manufactured home, and tomorrow we're actually due to sign the papers for closing, which I'm very excited. Me and my husband are very excited about.
First home?
Yes.
Congratulations.
Yeah, it's been a long run, but we've worked hard to get our credit straight and all of that. And so finally we got approved, and we're very excited about that. We also have two young boys that we're trying to make sure that we have a very safe place for them to live as well. And the area that we're going into, my husband grew up there. I did not grow up in the MLK area, but this is our first home. We're excited about it. Our children are excited about it. And hopefully one day when we're gone on, they can have a roof over their heads still. You know, home is always open to them. So basically that's why we're here, and we're asking for approval if at all possible.
All right, thank you, Ms. Jenkins.
Okay.
Any comments from the board? Questions from the board? All right, thank you very much. Would you like to speak, sir?
Yes,
I'll
I'm
need your-
Lamar Jenkins, and we at 1415 Audrey Lane. The present address we're trying to move to is 5908 King Street. I have lived in this neighborhood all my life, and we're trying to, build up our neighborhood by bringing more houses in, because the neighborhood has grown up a lot, and we're trying to get this variance, and then the variance is only a foot over the property line, and we're trying to get the approval for the variance because that foot.
All right. Any questions for Mr. Jenkins? Thank you very much.
All right.
Anyone else wish to speak for case 23-4?
Hi, my name is Alice Adams Williams. I just purchased some lots in the Union subdivision. Mr. Jenkins was saying that he would be a great asset to the community. It's going down, it's growing up. What we're trying to do is get people to come back to the community. So they can start paying tax, and we can just liven the community back up, because it's nothing but vacant lots there. Vacant lots and horses. So we are trying to put some houses in there and just do the community like it was. My husband grew up in the community. I used to visit a long time ago. And it had a lot of people there, and everybody was friendly and nice. And right now, it's a good community. We don't have any problems in that community. So I'm there trying to help bring up the community. I started building a tiny house at 5630 Day Street, and I have purchased some more lots from the city, and I intend to put some more there, but we just need to bring the community back up to date. And thank you.
Thank you, ma'am. Anyone else wish to speak for case 23-4? There's only about 4 of us in this room who, when the word horse gets mentioned, we have a shiver up our back. We used to have a lot of horse issues. All right, anyone wish to speak against this case? 23-4? All right, what do we hear?
I move to approve.
My second.
Motion by Mr. Hendricks, second by Mr. Woods to approve. Please vote. Motion carries unanimously. Case 23-5, Francis Street.
Hello, good afternoon. My name is Jesus Gonzalez.
I'll pull the microphone a little closer.
Good afternoon. My name is Jesus Gonzalez, and this is my dad, Jesus Gonzalez. Well, I'm a junior, so yes, sir. We live on 9208 North Southland Park Drive, and we were wanting to know if we could get approval on moving into Francis Street, or 0 Francis Street. And so, well, it's me and my dad and our family. I have 2 sisters and 1 little brother and my mother. And so we were wanting to know if we'd get approval to move in. So far, we like the place because it's a good place to live. Like, there's a good place. So I play soccer, and so it would be a great thing for me, and so would for my little brother if he would like one day get to like to live there too. So we wanted to know, as I said again.
Sure. Yeah, I think we're almost there. I just want to make sure you understand the recommendation from staff has 3 main stipulations, which will be requirements before you actually get signed off on a approval, right? And that is that the front porch will get replaced when you move it in, right? You'll have a new front porch constructed.
Yes, sir.
That the siding will be repainted, or pressure washed, repainted, whatever, to make it look nice and clean and new.
Yes, sir.
Because the photographs, it seems to have, I couldn't tell if it was vegetation growing on it or if it's just stained.
Yes, sir. It was mud.
Right. And then also you have to submit a revised site plan showing where the driveway and the 2 parking spaces will be included. That will be required, that will all happen subsequent to our voting today. We understand those stipulations?
Yes, sir.
And you agree that you agree to do
yes,
those?
sir.
Okay. Any other questions from the board?
Yeah. Are you going to be the owners of the property?
Yes, sir.
You own it, okay.
No.
All right. Thank you very much.
Thank you.
Anyone else wish to speak for case 23-5? Seeing no one. Anyone wish to speak against? What do we hear?
Move to approve.
Second.
Motion by Mr. Hendricks, second by Mr. Crawford. Please vote. Motion carries unanimously. That takes us to tab 10, which is case 23-6, BAC.
Good afternoon, Mr. Chairman, members of the board, Mr. Clark, Mr. Jean, and other staff here. Thank you all. Okay, you have that. You're going to use that one. I'm William Bradford. I am a partner at Blanchard, Walker, O'Quinn, and Roberts, 333 Texas Street, Suite 700, Shreveport, Louisiana, 71101. I'm here representing the owner, RK Firm Phase 1 LLC, located at 1380 East 70th Street. Before you is a variance request for, it's a 70-foot variance request for the use and sale of off-premise alcohol at Whole Foods located on East 70th Street. The staff report gives you a fairly clear background. This property was developed prior to the city of Shreveport adopting or removing the separate entrance requirement for alcohol sales within its jurisdiction. This property is a large sales tax driver for the community. It has a very clear and defined site plan that was approved by the city. And as a result of the overturn and repeal of the separate entrance, is now requesting the ability to sell alcohol on premise for off-premise consumption. The store currently sells beer and wine and is located, and the issue before you is that it is located within the 1,000-foot distance requirement as set forth under the UDC for the distance between sale of alcohol for off-premise consumption. Again, this is a request for a 30-foot variance, and we have provided in the application some information that would help to help this board to determine whether or not it should use its discretion and jurisdiction to allow for this variance. The first of which is, if you look at that map, thank you, this shows you, this question is really a lot line to lot line question, not a building to building question. It's very clear that our property extends well beyond 1,000 feet. The building, excuse me, extends 1,000 feet beyond Kroger. However, the standard under the current ordinance or UDC provision is, property line to property line. Now, the intent and scope, and I believe the staff report does a very good job of articulating this, was to discourage in close proximity standalone liquor stores. This is a grocery store. It's a full-service premium grocery store based out of Austin, Texas, which is located here. Again, it is a huge sales tax driver for this area. I agree with 98% of the staff report. There is no significant impact to the surrounding area. Excuse me. There's specific language within the staff report that says the intent of the 1,000-foot distance requirement is to limit the density of liquor sales establishments and to ensure the liquor stores cannot cluster in any given area. All distance requirements that are mandated by the UDC are measurements from lot line to lot line. He continues that from a functional perspective, Whole Foods does meet the spirit of the proximity requirement, but because of how the lot lines lay out, we are within that 1,000-foot distance. He also continues that this will not add another building or suite to the retail center. It will be a fully interior section of the sales floor that will be dedicated to the sale of liquor. The average consumer will likely be able to eliminate a trip to a dedicated liquor store if Whole Foods would be able to sell liquor. So there is a significant benefit to the local consumer from that perspective. He also continues on that there is no major significant impact to the surrounding temperature or aesthetic of the community. In evaluating this, the Zoning Board of Appeals must make findings to support the following criteria: that strict application of the terms of this code will result in undue hardship unless the specific relief requested is granted. B, that the plight of the owner is due to unique circumstances inherent to the subject property and not from the personal situation of the owner. And C, that the variance is granted, if granted, will not alter the essential character of the locality. I think item A, let's start there. The strict application of the terms of this code will result in undue hardship unless a specific relief requested is granted. Again, this speaks to the spirit of the law. What kind of unreasonable results will occur in the strict application of this distance requirement under these circumstances? And what you have is a premium grocery store providing services to the surrounding community unable to sell or be competitive in this market space. The second thing that you have is the plight of the owner is due to unique circumstances inherent to the subject property and not from the personal situation of the owner. Again, this is an established venue. This property has been in Shreveport for several years, and the site plan was approved prior to the city's repeal of the separate entrance requirement. And so there's a meaningful instance here where the unique circumstances have changed, and it is at no fault of the owner, and the owner has not had any ability to change its current circumstances. This is not a result of the owners or the ownership group's application or position. This is not a new facility, this is an existing facility. And of course, item C, the variance is if granted, will not alter the essential character of the locality. The staff report specifically speaks to that and shows that it will not alter the specific character of the locality. And so our prayer today is that this board will grant the variance, a 30-foot variance. And I want to be very clear, this is not an economics question. This is a geography question. Again, you have an established business that is contributing to our community, that is wishing to provide services similar to its competitors. And by its geography and pre-approved site plan prior to the change in law, it would, but for that, would be able to sell, if the number had been 1,300 feet, whatever number was come up with, it could potentially have been within that strict restriction. And so this board has the absolute discretion to grant variances in instances such as this, where the outcome in the application of this particular standard becomes so onerous that it becomes prohibitive to good logic and good business. And so our prayer today is that this board will see the efficacy of this argument, show that the spirit of the law is still met because our building is outside of the 1,000-foot restriction, and that when evaluating the property line discussion, that the imposition of this distance requirement as written on this circumstance, specific circumstance, creates an unreasonable outcome. And so we are requesting today the variance of 30 feet so that Whole Foods can make application for the sale of off-premise sale, make application for off-premise sale of alcohol. Thank you.
So I'll just lead off with one question, which is relating to the criteria under B, which you mentioned, which I think could be solved if the owners of the property would subdivide that driveway section. It is an odd-shaped parcel, which we all can see on the map. If it weren't for that horizontal leg running across, it would be by right, right?
Sure.
Did they consider subdividing and making that a separate parcel that was not included, that therefore would not be included in consideration of that 1,000-foot limit?
We have considered, and I want to break this into two responses. The first of which is that the steps required to subdivide it and then remove it from the ownership group of the current applicant is very cumbersome, burdensome in this instance.
It wouldn't have to be separate owners. It would just have to be a different lot, because the building in question would not be on that property, if I understand that correctly.
Understood. But again, going through the process of subdividing it and clarifying it, to your point, again, is more cumbersome than the current and initial application for the variance, right? The second thing is, and this is more of a policy issue for this board to deliberate, is does the ZBA want to get into the business of telling property owners in a general context how to articulate their property for sale or for transfer or for subdivision? And so while it's within the power and purview of the ZBA to do so, in this instance, the most clear and defined result or remedy in this situation would be a 30-foot variance.
Right. If we feel that you actually have a hardship,
right,
going through the process to subdivide the property would eliminate the hardship, which A, would give you the right to the liquor license, right? We're not telling you what to do with your property.
Understood.
We're telling you a remedy, an option to get to it that doesn't require us to give a variance outside of the criteria that's set down for us.
I understand the position, and again, the client appreciates that, but again, redividing or subdividing its property is a step that its druthers was to go through this variance application process, because this is a remedy afforded under our current laws, and it does not require them to make impact to their property, to whether it be appraised differently, whether they're financed differently. I mean, there's other steps that have to go into how this property is managed and maintained. And again, this property is part of a larger strip center. It's part of a larger development. And so there are some folks smarter than I am on the engineering side who've made the determination. And again, I want to re-articulate, this was an approved site plan. This was the site plan that would rent through the deliberative process with the ZBA and with the Planning Commission. And so their preference is to keep the site as it is
Right.
and seek the variance.
But it was approved without this, we're now
Without this issue.
changing the parameters.
Right,
They're-
yes,
They're
sir.
wanting to change the parameters, which certainly their prerogative. But we also have to think about how we manage variances.
And I want to, if I may follow up to your point, this is a very specific issue, right? I understand the reservation of the ZBA to grant variances because it creates this spectrum of issues that you may be approached with. But in this instance, you have a very articulable delineation and differences in many of the issues that you will see. First, you have an established site plan, an established building. You also have a grocery store. This is not, again, the spirit of the law was clear in that it is addressing the issue of proliferation of liquor stores ordinarily in economically depressed communities. This is not that type of case.
I agree with you that it should be building to building.
Right.
But operating under the situation we have now, I'm just trying to, square my responsibility as an individual board member, not speaking for anyone else, how I get to a variance if for me, there's not a really clear, meeting of these three requirements. And
Sure.
That's just for me. So, and in fact, I'll pass it on to someone else if they have a question. I think we've kind of settled what we need to settle.
So, Mr. Chair, Mr. Bradford, I think you were the city attorney when the ZBA and the MPC created this original, before the changes. We had the division and you had to have the separate entrance coming into the store and those types of things. And so in this particular area, talking specifically geographically, how many liquor stores can be found within, I don't know, a mile radius of where you're looking to put those additional alcohol sales into? I know we have the Kroger, obviously,
Sure.
because that's the
That's
marker
the issue,
that you're
right.
being measured against.
Right.
But in the other areas, I know there's retail alcohol sales in some of the restaurants that are in that same shopping center that you are. But as far as just liquor sales, whether that is a commercial business or it's just a standalone liquor store or it's a supermarket.
There are none. This would be, within a 1 mile radius, the likely only one for that area. And I think the staff report speaks to how this has minimal to no impact on the surrounding area.
And the distance between the closest residential property?
It's more than the 300 feet, more than the 200 feet required, and well outside 300 feet. I think the next neighborhood over is behind, would be to the, somewhat directionally challenged. I guess that's going to be to the west on Fern.
Okay. Can you speak a little bit more to the spirit of why the law was created the way it was? You mentioned it a while ago, the spirit of the law to minimize the number of liquor stores on every corner, so be it in particular neighborhoods.
Sure, absolutely. I think the most definitive measure of this was the impact that it was having in economically depressed areas and the proliferation of liquor stores in those areas. That was the impetus of the distance setback requirements, or the distance requirements. I do not believe that it was ever considered to impact bona fide grocery stores who are already permitted for alcohol sales. That's an instance, and a very critical part of this discussion is that this property already sells beer and wine. And so it is not additive, in the spirit of the law, it is not additive to liquor sales within that community. They exist. And so in this instance, you're talking about a branded store that is seeking the ability to remain competitive in this market. And so, again, as we speak to the hardship issues, as we're speaking to the spirit of the law issues, the ZBA has broad discretion in making steps to alleviate unreasonable interpretations of the law. On its face, I agree with you, Mr. Berry, that there are other issues, there are other ways that maybe this could be addressed. But when you're talking about the impact of a variance in this instance, it's a very specific set of facts that you're weighing in on, and each variance is weighed separately. To your point, Mr. Crawford, about the ultimate outcomes here, there is a real impact for business when our zoning administration, our review boards, our bodies such as the ZBA and the MPC, there's a real impact when they see the reasonableness of business. And so in this instance, you have, again, a responsible vendor a very responsible, full-service grocery store. And again, to the spirit of the law, building to building, this meets it. Now, should this property owner go in and have to go through the maturations of dividing its property when there's a remedy such as a variance for a very specific issue like this? I don't think, and again, one of the biggest distinctions in this is that the building is farther than 1,000 feet. So if I had a very large piece of property, if this is the instance, that could create all sorts of problems.
Mr. Woods? Yes.
Thank you.
Yes. Mr. Woods? Yes. Mr. Williams, you said that there is no, or I believe you said there's no real impact on liquor sales because the liquor stores that's close to this was within a mile, and that there would be no real impact on liquor sales coming from Whole Foods?
Well, in reference to your question, the staff report specifically says that we must also consider how an approved variance may alter the essential character of the locality. Approval of the variance will only allow for Whole Foods, an established grocery store, to be able to sell liquor in the interior of this business. And it continues on that it already sells that beer and wine. And two, this is completely contained within the strip mall, and there are also alcohol sales within that strip center for on-premise consumption as well. And so there is not a proliferation. The spirit of that law, that distance law, was to prohibit a proliferation of alcohol stores.
But the spirit of that law take under consideration the impact that this will have on independent standalone liquor stores, because those sales that you're talking about is going to come from somewhere. It's not that they don't exist. In other words, all retail grocery stores will have a huge impact on the independent stores. So to say that there's no economic impact, there is an economic impact with liquor stores that may be miles away, not just 1 mile, but because people live in areas and shop in other areas, it could have a tremendous impact on the independents. And then one of the questions I want to ask is, and I think you would acknowledge that it would, those sales coming from somewhere. So
Well, I can respond to that, or do you want me to wait till you're...
no, go ahead.
Okay, so in response to that, I can't opine on what economic impact it'll have on the independent stores, but I will tell you this, that the most impactful change to the law was the removal of the separate entrance requirement. That's the impact. That is the drug. So you're not preventing grocery stores and other bona fide retailers from selling alcohol with this distance requirement. What we're creating, and what we have created, is a race to the courthouse, as we call it in the legal community. You created a situation where it's whomever's the first to file. Had we filed first, Kroger would have the same problem. But you don't stop, by imposing this distance requirement, you don't stop retailers, bona fide retailers, from selling alcohol. It is just, there will be another store somewhere down the road.
You do if we go adhere to the variance, you don't stop them, but they would at least have that minimum requirement that says that they have to be that far apart, because they are going to proliferate. How can liquor sales not proliferate?
Right, and
if we don't adhere to those guidelines that were supposed to change the impact to the minority stores in the minority community. How do we?
And I would like to reaffirm that this is not a new store. And I understand, Mr. Woods, I understand you are very vested in this, right? You have a store on East Kings.
Full disclosure.
And to say that it will not have an impact, I can't opine on that. But what I can say is that Whole Foods sells beer and wine.
True.
That it is, again, we're talking about a very specific and tailored variance that can be articulated and delineated from any other future application, in that this is a grocery store that, but for this distance requirement, meets all other requirements to sell alcohol. And that on its face, it would meet the spirit of the law, but for the fact that the definition requires property line to property line. And so, again, the board is empowered to avoid such burdensome interpretations of the law when that impact adversely affects business in our community. Now, I would make the argument, Mr. Woods, that there is a positive impact on your defined liquor sales because there is a improved consumer experience, and you have your loyal customers who are going to travel to your store, just like Whole Foods has its loyal customers that are going to travel to its store. So this is a community-wide impact. But again, within your sales area, I can't speak to what impact, negative or positive, that it may have. They may go to Whole Foods and figure out, hey, I like this new alcohol, this new type of beverage, and you're closer. So now, because this person's had a new experience at Whole Foods, they may turn around and purchase from you. I don't know. But what I do know is that the interpretation as it stands, and again, I say I agree with 98% of this staff report because it gives you every reason why to approve this variance in this particular instance. But a draconian application of that distance requirement under these circumstances, and again, we're not asking for a 1,000-foot variance, we're asking for a 30-foot variance. Approval of this today abdicates our requirement to go in and subdivide, spin up all legal, to do all those things necessary to go through the subdivision of that property, recording of that property. This is an opportunity to solve this problem in a very specific and tailored environment for this particular issue.
All right, any further questions for Mr. Bradford? All right, thank you very much.
Thank you all for your time. Thank you. Thank you, Mr. Clark. Thank you, Mr. Jenkins.
I don't see anyone in the chamber, but just for the sake of propriety, anyone else wish to speak against or for, pardon me, speak for or against 23-6? All right, what do we hear?
Mr. Chair, before you vote.
Mr. Clark?
Just on behalf of the staff, I'd like to make a comment, please. That we have strict criteria for granting variances. And the staff has shown you, after all the eloquent speeches that have been made, that, and I don't think, because I worked on the liquor store ordinance as it worked in the Metropolitan Planning Commission, that it was just for black interracial neighborhoods that we created the 1,000-foot spacing requirement. We recommended the 1,000-foot spacing requirement in order to ensure that there were no liquor stores within 1,000 feet of each other. The only thing that we failed in our recommendation was to remove the possibility for a variance. If 1,000 feet is from property line to property line is not sufficient, or if you disagree, then you need to recommend that the Metropolitan Planning Commission recommend changing the ordinance from building to building. But the ordinance as it is, we feel that it's a great ordinance. We feel that it was a unanimous decision by the City Council to establish these parameters, and no economic status or economic conditions or any point within any point in the city to change what has been created. What's good for MLK is good for Uri Drive. And once we forget that there's not a difference between the people at MLK and Uri Drive, we neglect our responsibilities as citizens of this great city. So I just caution you. I think you're creating a situation where you're establishing favoritism for a particular part of the city, and you're hiding behind the fact that it's for economic development. The ordinance is the ordinance. If you don't like the ordinance, we need to change the ordinance.
Well, I guess my response to that was, isn't that true of every variance that comes before us?
It is true, but every variance that comes before you, we continue to share with you that the criteria requires there be a hardship. If you don't want a hardship to be the driving force behind a variance, we need to change that law. I mean, I think that we just sit here and break the law, but I've always been told that my 28 years with planning and zoning, that if you don't feel a law is legal, you don't feel a law is enforceable, you don't feel that a law is fair, change it. That's an easy solution.
But a lot of the laws have changed because we've had a proliferation of variances that pointed out a problem.
But this one is not that. If it needs changing, we will go to the MPC board and suggest to them to recommend changing the law. Happily.
So where does that leave this applicant in this situation?
There is not justification to grant a variance. There is no hardship that prevents them from complying with the ordinance. Therefore, as we have recommended, it needs to be denied.
All right, thank you, sir.
Thank you.
All right, with that, what do we hear?
I move that we deny the variance.
Motion to deny by Mr. Woods. Do we have a second? Motion fails.
Mr. Chair,
Yes.
I make a motion to
Crawford.
grant the variance for the applicant.
Second.
Motion by Mr. Crawford, second by Mr. Brannon to approve case 23-6. Any discussion?
Mr. Chair,
Yes, Mr. Crawford.
I take this role up here very serious. I take exception to the fact that it would be implied that we would make a decision based off of geography. If this store were anywhere else in the city, I would make the same decision based on the fact that, and I think you stated it, Mr. Chair, we are here for a reason. If we weren't here to hear specific variances to what the laws were, there would be no reason for a ZBA board in the first place. The staff could just make those decisions and we wouldn't be here. There's a good opportunity that no matter what we decide on this, it will potentially be appealed, and that hearing will have a bigger audience, I'm sure. But I think the applicant makes a strong point in saying that this adversely affects commercial business in a city that has been plagued for decades with at least the perception, and Mr. Clark knows this too, and I'll say that, perception, that it's difficult to do business in Shreveport. And we've lost a lot of business due to that perception. But sometimes that perception, before you're taking over this role, has been a reality. I've heard it working with city government, you've heard it before. There's a lot of hoops and hurdles. And I think common sense needs to come into place at specific times like this, when we know, or what we believe to be the intent of this law to be. And I don't think it was because of how property lines were construed to be. If somebody was on a 100-acre tract of land and they put a building in the back of that tract of land and they were miles from the other liquor store that we were going to measure from the point most distal from that building. I think the spirit of this law was to keep the clustering of buildings that are selling liquor from propagating in any area of town. That doesn't do this. This is a good community business partner that has come before this body. They meet the residential requirements. They have a point, and to your point, Mr. Clark, I look at these requirements. The strict application in terms of the code will result in an undue hardship unless specific relief is requested. I believe that burden has been met. I believe that going back to a property owner and having them subdivide their property is an undue burden. The plight of the owner is due to unique circumstances inherent to the subject property and not from the personal situation of the owner. I believe that also to be true. This was not the law when the store was constructed. It's a law that has been thrust upon them. And 3, the variance, if granted, will not alter the essential character of this locality. I believe that also to be true. So I believe they meet and surpass that burden. And for that, Mr. Chair, I'll be voting yes. Thank you.
Thank you, Mr. Crawford. Any other comments?
Yes.
Mr. Woods?
I have a comment. I take what you say at heart, Mr. Crawford, but I say this, and I believe Mr. Allen is right. If this was an applicant in any other part of the town, especially in a minority, it would not be approved if it did not meet the 1,000 feet variance. It would not. No, that's just fact.
I would vote for it.
That's just fact. It would not meet, it would not be approved. So I take exception to the fact that we don't realize that there is favoritism and that this is a big chain store that's asking for, to say, Mr. Crawford, that they're a good business partner. They're a grocery store. Now they want to be a liquor store. We're not saying that Whole Food does not have the ability to do business in Shreveport. They are. They're not even depending on liquor for their profitability. They're adding liquor for their profitability. So they are a good partner, but so have the city of Shreveport been a good partner. And to say that adding liquor is to this store is somehow going to make or break it, it's not. It's just adding more revenues. It is economics. I know you didn't, but it's adding more revenue. And it is going to impact the independent retail liquor stores or good standing liquor stores.
Any other comments before we vote? All right, the motion on the floor is to approve. Please open for voting. Motion carries 3-2. Thank you. This takes us back to case number 23-3. I don't see anyone here. No one has shown up. Do we hear a motion?
Mr. Chair, would it be appropriate to make a motion to carry it to the next agenda, give them another opportunity?
We can certainly do that. That'd be a defer and continue for 30 days.
Okay. Make that motion.
Second.
All right, motion on the floor is to defer and continue case 23-3 for 30 days or till the next meeting by Mr. Crawford, second by Mr. Brandon. Please vote. Motion carries unanimously. That brings us to the end of our public hearing. We don't have any committee chair reports. Mr. Clark?
I have nothing, sir.
All right. Comments from the board? All right, thank you all for today, and thank you for the staff for helping us out. As always, do we have a meeting next month?
I'm sure you do.
Okay, all right, we'll see everyone next month. Thank you very much. Thank you, sir. Thank you. Mr. Crawford?